The Honourable Courtney Houssis.
Thank you, Madam Deputy President, and I rise to speak to the Enclosed Lands, Crimes and Law Enforcement Legislation Amendment Interference Bill 2016. Madam Deputy President, this is an anti-protest bill, plain and simple. Let's be clear, this bill has been drafted for no other reason than to restrict a citizen's right to protest government decisions, specifically about mining, in this state. And we on this side of the House will strongly and unashamedly oppose this attempt to intimidate and criminalise farmers and other community groups who oppose the granting of mining licences on fertile agricultural land. But further to that, the drafting of this bill is such that these laws will apply to all protesters in New South Wales. They are draconian laws that increase some financial penalties for peaceful protest by more than 1,000% and introduce a penalty of 7 years imprisonment for these offences. These laws create a new power for authorities to search and seize property without a warrant. And they aggressively undermine the rights of citizens to protest government action by giving authorities additional powers to direct the movement of people in public places. This bill goes far beyond the police powers that apply to public assembly and demonstrations in New South Wales, and there should be no illusions that the current laws are inadequate. Indeed, for the benefit of the House, I will detail just some of the current offences that could apply to people engaged in public protest. There are breaches of the peace under common law. Under the Summary Offences Act 1988, there's obstruction, offensive conduct and language, violent disorder. Under the Crimes Act 1900, there's affray, assault during public disorder, assault and other actions against police officers, riot, destroying or damaging property, interfering with a mine, and intimidation or annoyance by violence or otherwise, including hindering. Under the Forestry Act 2012, there's obstructing and hindering and assaulting, threatening and intimidating, as well as under various other acts, unlawful entry and offensive conduct on enclosed lands under the Enclosed Lands Protection Act 1901, obstructing and hindering under the Mining Act 1992, obstruction and causing a traffic hazard under the Road Rules 2004. This shows that there are various legal harms this bill is purporting to address are already well covered by existing legislation that operates in this state. Legislation that, on balance, protects both protesting parties and those affected by demonstrations. And because it's important, let's acknowledge that these new laws will apply to peaceful community groups, groups like the Knitting Nanas, residents' action groups and farm owners who legitimately oppose government decisions. Peaceful groups that have emerged in response to the actions of this government, who said one thing before the election and have acted in direct contradiction after it. In fact, I don't think it would be inaccurate to say these laws are precisely targeted at groups such as the Knitting Nanas and law-abiding farm owners. And beyond these groups, whether we agree with a particular protest or its subject matter, it should not be the role of this Parliament to infringe upon the rights of our citizens in such a dramatic way without proper cause or explanation. It is plainly absurd to increase a fine by more than 1,000% when there has been no clear evidence put before this Parliament to indicate current infringements are not adequately servicing their purpose. It is quite alarming to allow authorities to search and seize property without a warrant and based solely on suspected future use of items that person may or may not be in possession of. Ordinary items such as ropes, locks and chains. Let us consider what that means in practice for a moment. A farmer who may attend a protest, as many have in recent times, to protect our valuable agricultural land, driving their vehicle, perhaps a ute or a small truck or a four-wheel drive. Under the powers granted by this law, if he or she has ropes or chains, not unusual items for ordinary work on a farm, the vehicle could be permanently seized by police. Permanently seized. This is clearly a disproportional response to a peaceful protest. Now, I have participated in a few protests in my time, but I am not being an anarchistic ideologue here. There are grave concerns among the legal community about this bill. Surely there is no more qualified group than the New South Wales Bar Association, which has labelled this bill unjustifiably broad and has said its effect will be to prevent
The opposition whip on a point of order. Order.
Taking out your own member's time.
Getting beyond his time.
No, the clock stops,
But
mate.
I can't hear the member give a contribution.
It's only your time.
I uphold the point of order. Despite the level of noise from the government benches, I could hear the member was pointing out that there is a lot of noise in the chamber. The Honourable Courtney Housas to continue.
Thank you, Madam Deputy President. Surely there is no more qualified group than the New South Wales Bar Association, which has labelled this bill unjustifiably broad and has said its effect will be to prevent or disrupt peaceful assembly in this state. There are surely members opposite who know this bill is erroneous and misguided. My friends in the National Party who claim night and day to represent regional people and their interests must be wondering how this will play out when the full force of the new laws come crashing down on farming communities who legitimately and peacefully oppose mining on agricultural lands. Or local community groups opposed to the government's deeply unpopular local government amalgamations. Indeed, it is deeply concerning to me that it is unclear how this bill will apply to industrial disputes, and now celebrated actions such as the infamous green bans would actually be rendered illegal. This isn't about being on the right or the wrong side of these issues. It's about understanding the role of this place and appreciating that whether we like it or not, citizens in this state have a legitimate right to protest government decisions. This bill is disingenuous and dangerous. It attacks the common law right to assembly. It attacks the common law right to assembly, and it does so flippantly and without proper cause or explanation. I am strongly opposed to this bill, and I appeal to members to vote against it.